Hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeev Bhatia again with a new video on your legal affairs for your CLAT and AILET in 2022 and 2023. So if you are new to the channel, please hit on the like, share and subscribe button for regular updates. And also make sure that you are hitting on the bell icon so that you know when our new videos are coming up. Now, if you are not a part of a Telegram channel, do make sure that you are subscribing to our Telegram channel under the name of CLAT@Pratham for all the news and article updates that you require for CLAT examination. Now, coming to the first legal affair for the day is that married brother of deceased government servant is not a dependent and is not entitled for compassionate appointment. So what is a compassionate appointment? When a person who's on duty for a government job dies on duty, so the person who's their legal hire will get the next best alternative job that is there for them. So that is called a compassionate appointment. Now, the Rajasthan High Court has observed that the petitioner is a married brother of the deceased government servant, and therefore the petitioner cannot be held to be a dependent and to be entitled for compassionate appointment in the terms of Rajasthan Compassionate Appointment of Dependents of Deceased Government Servant Rules of 1996. Now, there was Justice Rekha Borana who said that while dismissing the writ petition, opinionated, said that admittedly the petitioner is married, therefore in terms of rules of 1996, the petitioner cannot be held to be a dependent and to be entitled for compassionate appointment. In the view of the provisions of law, this court is not inclined to interfere with the order dated 01/01/2019. So he was ordered that he cannot get a compassionate appointment in 2019, and he definitely brought it to the High Court, and the court has said that that's not possible because he's the married brother and he is not eligible for a compassionate appointment according to the Rajasthan Compassionate Appointment of Dependents of Deceased Government Servant Rules of 1996. Right? Now, coming to the next news of the day is that the court has said that Air India is now a private company. This is what the Karnataka High Court has said to refuse to exercise writ jurisdiction under Article 226 on the employment's plea, right? Employee's plea. Now, the Karnataka High Court said that since Air India is now a private company owned by Thales Private Limited, the grievances of the employee can be redressed only after the competent authority which can be deal with the question and not under Article 226 of the Constitution of India. There was a single judge bench of Justice R. Devdas who made the observation while dismissing a petition filed by petitioner Padmavati Subramaniam and two other employees of Air India Limited. Now, the petitioner had approached the court with a grievance in the matter of seniority. Now, the court said that it is clear that Air India is a private company owned by Thales Private Limited. Earlier position of Air India Limited, which was fully owned by Government of India. Now, the company has changed and it's now a private limited company. Therefore, the grievances of the petitioner in the matter of seniority can be redressed only before the competent authority which can deal with the question and not under Article 226 of Constitution of India. So that's what the court at the Karnataka High Court has said, and they have refused the petition of writ in the High Court and said that Air India is now a private limited company, so it doesn't cover the same employment rules that they used to earlier. Right? I hope everybody is clear with this and you are able to understand this, what Karnataka High Court has exactly said. Now, coming to the next part is that Section 370 can't be invoked on the presumption of like the person is indulged in the human trafficking, right? That's what the Karnataka High Court has said. And then the invoking merely on presumption of the accused indulging himself in human trafficking cannot go on and book him under Section 370. Now, there was a single judge bench of Justice M. Nanga Prasanana, and while quashing the criminal proceeding initiated against a person called Rajkumar, what can be gathered from the complaint and the charge sheet that is filed by the police is that it is presumed that the petitioner had indulged himself in human trafficking and therefore section 370 of the IPC was invoked against the petitioner. Right now, it also added that the soul of the provision is exploitation. There is no allegations in the complaint made by the victim allegedly exploited by the petitioners. The complaint, investigation, and wavering statements of the persons who accompanied the petitioner created suspicions in the mind of the immigration officer. And also, the suspicion was on account of the statement of handing over some cash to the petitioner by the people who accompanied him. Now, this cannot be, in my consideration, due be enough circumstances to prosecute the petitioner for offense punishable under 370 of the IPC for human trafficking. So the mere presumption that the person was doing so, or is giving such a statement, or is handling such things, is not gonna let you inside the jail. So a presumption of human trafficking is not enough for someone to be booked under that. Now, Gujarat High Court has said that the government has to clear its stand over the ban on using loudspeaker in mosque. As you know, this has been a lot of news, and there's been a lot of dispute that is going on in Delhi, in Jangirpuri. So there are a lot of factors that need to be considered in this regard also. Now, the Gujarat High Court asked the state government to clear its stands on the use of loudspeakers for azan in mosques all over the state. And also the bench of Chief Justice Arvind Kumar and Justice Ashutosh J. Shastri was dealing with public interest litigation filed by seeking a direction to the state government to take appropriate measures for banning use of loudspeakers in the mosque all over the state. Right? So there are a lot of things that are going on this topic also, so you can definitely give it a read. Now, President has given an assent to the Criminal Procedure Identification Act and Delhi Municipal Corporation Amendment Act. We have discussed both of these acts in detail on this channel itself. President has given its assent to these acts, and they are finally passed. Now, they have also given the assent to the merging of Municipal Corporation of Delhi, that were the three municipal corporation, SDMC, North Delhi Municipal Corporation, and EDMC, that is the East Delhi Municipal Corporation. So the president has given his assent to the both the acts, and also made it very, very clear that this will be applicable now. Now, SCs and ST Act, when the offense appears to be a misuse of law, the court has the power to grant anticipatory bail. Now, the Chhattisgarh High Court has recently remarked, when the offense of SC/ST Prevention of Atrocity Act appeared to be a misuse of law, the court has the power to grant anticipatory bail. Having held that Justice Deepak Kumar Tiwari granted anticipatory bail to an accused under SC/ST Act. Now, the accused appellant had filed an appeal under Section 14A2 of the SC/ST Prevention of Atrocities for anticipatory bail, and he was punishable under a lot of offenses that were there. So definitely, if there is a misuse of law that the court can see in such a case, then they will give the person an anticipatory bail. That's what they have said. So this is it for today, guys. Thanks for joining this live session. Hope you learned something new about these legal affairs. So do take care of yourself and have a nice day ahead. And do make sure that you are liking and subscribing to the channel, so that we can make further videos for you guys. So do take care of yourself. Bye-bye, guys. Have a nice day ahead.